Welcome to SST College of Arts and Commerce. This is SST Edupedia. Myself, Assistant Professor Sunil Shah. Today, I will be covering up the topic called Payment of Gratuity Act, which is there in the syllabus of Industrial Law in BMS SEM 2 of Bombay University. Payment of Gratuity Act 1972, it was been incorporated by the Parliament of India. Gratuity means some type of saving which is done by the employee in collaboration with the employer, which is used for his older age. Coming to the introduction part of Payment of Gratuity Act, it lays down the minimum benefits to be provided to the employees. It is a social security enactment providing for the welfare benefits of the employees working in industries, factories and organization. Coming to the applicability part of the act, it is applicable to those workers who are working in mines, those persons who are working for the oil plantation industries, taking out the oil from that particular castor or any from the coconut oil industries, or those workers who are working in railways, and also for those type of establishment where more than 10 or more workers are working in the preceding 1 year. It can be also applicable to any other establishment employing 10 or more than 10 persons. The payment of gratuity is payable if there is a continuous period of services given by the employee to his employer, not necessary in case of death or in case of permanent or total or partial disablement. It is not necessary in case of termination due to superannuation or retirement. Also, gratuity is payable in case of resignation, death or disablement due to accident or disease which has been caused to him during the course of his employment. In case of death, the amount of gratuity would be payable to his nominee or his legal heir, which is he has been given his consent while filling up the form. The calculation part of gratuity is the formula which has been given is as follows. If it is done according to this particular formula, the last drawn salary, the monthly salary divided by 26. Why we are taking 26? Because we are reducing the number of Sundays, multiplied by 15 and multiplied by number of years. So in this case, minimum is 5. How the gratuity is calculated? It depends upon the salary. Salary would be basic plus dearness allowances into number of years, how many years he has put up into service. Suppose the minimum cases is 5 and divided by 26 and multiplied by 15. So if you say 15 days wages, if it is the last drawn amount of the wages divided by 26 would be the amount multiplied by 15. So if the last drawn salary of the employee is rupees 2600, then that 2600 should be divided by 26 days excluding Sundays, multiplied with the number that is called 15 and multiplied by number of years he has put up into service. So in this case, 2600 divided by 26 days would be 100 into 15, that would be called as 1500 rupees, multiplied by, if this employee is working for 17 years, then 1500 multiplied by 17 would be, the gratuity amount would be rupees 25,500. So students, please go through this particular formula for calculation of the gratuity, which will be applicable to you also when you do your job or you become a manager of any of the company. This particular formula has to be calculated for your employee, for your employers. The modes of payment of gratuity, coming to the act, what is mentioned in the act, it can be also paid by cash or DD or through the bank check, or if you come into this coming scenario, we are into the digital payment system, it can be paid through IMPS or through net banking or any other mode which has been provided by Negotiable Instrument Act 1881. It can be also made through postal money order if the amount of gratuity is less than 1000 rupees, and or if the employer desires that this particular form of payment has to be done, in that particular format only the employer has to pay his gratuity. The maximum amount of payable the gratuity as per law is rupees 3,50,000. The determination, application, notice of the payment of gratuity, In this case, the person is eligible to make a written application to the employer within 30 days when it is fall due. In such cases, if the employee is retiring, he has to write to the employer that please clear my gratuity. In case of the death, his legal heir, whoever would be the legal heir, must make an application within 1 year from when the gratuity becomes applicable. Determination, application and the notice for the payment of gratuity. In this case, as soon as the gratuity becomes payable, the employer must determine the gratuity. He should work out what amount has to be given to his employee, and even before the application he should start with the process and must send a notice to the person to whom it is payable. So there are two cases: either the employee would be writing to the employer, or employee would be suo motu, he would be self-acting, he would be writing to his employee through the in the form of notice that I am willing to pay such amount of gratuity for his continuous good work in the organization. And within 15 days of the receipt of the application, if the employee makes, the employer has to clear his gratuity. If the claim is inadmissible, so there are some cases where the claim is inadmissible, the employer doesn't wish to pay, then he should send a notice in the form M, which has been uploaded into the website of the government under the Payment of Gratuity Act, and it has to be paid within 30 days from the date it is become payable. So if the employer doesn't want to pay, he has to fill up the form M and has to inform to the authorities of the government that I am not willing to pay the gratuity to the so and so applicant for so and so grounds. If not paid, if the gratuity is not paid within 30 days, then the interest has to be calculated, and those particular amount of interest has to be added to the gratuity and has to be given to the employer, has to be given to the employee by the employer. No interest if the delay is due to the employee's default. But if the employer is in default, then the interest has to be paid to the employee. If now coming to the dispute parts, normally this particular aspect I want to cover up in this particular video. In case of dispute with respect to gratuity, the amount must be deposited with the controlling authority. Suppose there is a dispute between the employee and the employer, and during the cases when it is ongoing in the labor court or the honorable high court, in such cases also the employer has to deposit that amount of gratuity to the controlling authority, and the application must be made by the employer to the authority for the direction within 90 days of the occurrence. So whenever the court cases is going on, whenever the dispute has to be going on, the employer has to prepare the amount of gratuity, the statement related to the gratuity, and he has to inform to the controlling authority. Controlling authority must make due inquiries, and if the claim is found inadmissible, then he can direct the payment is to be made to the person entitled. So there are two chances: the controlling authority has to satisfy himself whether the gratuity has to be paid to the employee or not to be paid to the employee. Such issues for direct payment must be made to the employer within 30 days from the date of receipt of the same by the employer. Coming to the appeals part, so there would be some cases the employer won't pay that much amount of gratuity where he is entitled. In such cases, the right what the employee has, he has to appeal to the authorities. The appeal must be made by the aggrieved person, those persons who is working in the organization, and it has to write to the controlling authority. As per the act, the limitation is 60 days from the date of receipt of the order, which is further extended to 60 days if he satisfy him or he asks them to condone my delay, or if the controlling authority says that there is a sufficient ground why the employee has not been applied. Appeal is not maintainable if the certificate claimed by the gratuity amount issued by the controlling authority is not been produced. So it is mandatory that the controlling authority's order should be also produced and should be handed over to the employer if there is a dispute. What is the procedure for appeals? necessary entries made with respect on the receipt of the decision of the appellate authority. So once the dispute is going on to the labor court and the amount of gratuity is in the question, in such cases the employee has to apply to the controlling authority to hear to his appeal and give the decision, and after the decision is been given, he should ask to the controlling authority to please give it in writing, that is the order, and the order has to be submitted to the employer. This is the correct procedure for the appeals. Notice is issued to the employer and make him direct that to pay the gratuity after there is a dispute and after the resolution by the controlling authority, and within 15 days he should give him the gratuity. Now coming to the forfeiture of the gratuity. If the service is terminated by an act, willful omission, negligence causing damage to the property of the employer or destruction of the property, the forfeiture is to extent of the damage. So in many cases it may happen that the employer will say that I am not willing to pay to this employee the gratuity because of he has damaged my property. He was a negligent employee. He was not taking reasonable care of the company's property, so I am not liable to pay him the gratuity. In such cases, it would be called as forfeiture of the gratuity, and the gratuity can be wholly or partly forfeited. If the termination is due to riotous or disorderly conduct or violence of an employee or part. So, if you see in some parts of the country, the employee are disobedient to the employer, they are involved into rigorous activities or violent activities, or which is against to the national integrity of the India or the nation. In such cases also the employer has the right not to pay his gratuity, that would be called as forfeiture of the gratuity. And for the offence involving moral turpitude in course of employment, in such cases also he is not liable, the employee is not liable to pay the gratuity. The recovery of the gratuity, if the amount of gratuity is payable under this act is not bound by the employer within the prescribed time to the person entitled, in such cases also the employee can ask for the recovery of the gratuity. The controlling authority on an application by the employee, the application made by the issue of certificate that amount to the collector, who shall recover the same in case of government organization, together with the compounded interest thereon such rate as the central government deem fits, or it is been published in the official gazette by the notification as the areas of the land revenue, and pay the same to the entitled person. So recovery is mandatory. So recovery would be done by the employee from the employer if it is working in government organization, and it has to be routed through the collector. Recovery of the gratuity, the concluding part of the recovery of the gratuity, provided that the controlling authority shall before issue the certificate under this section gives an employer a reasonable opportunity of the hurt, and if he feels that the stand of the employee or employer is sufficient to prove, then only the controlling authority will give him the order. The amount of interest payable shall in no case exceed the amount of gratuity payable under this act. So students, please remember, the amount of interest payable cannot increase more than the amount of gratuity in whenever there is a recovery case of the gratuity. Coming to those part wherever the exemption is been granted to those particular organization, factories, the railways or the oil plantation companies or any other organization, which are those organization which has been exempted for paying the gratuities, the appropriate government, whatever the government, state government or the central or the state government may think fit, they will say that to exempt such particular organization for payment of gratuity. To whom it is applicable? To those establishment, factory employees or class of employees employed in any establishment, factory, etc., and in the receipt of the gratuity or the pensionary benefit not less favorable under this act, they would be exempted. Coming to those part related to the nomination, those names has to be included whenever there is a death or any unseen circumstances occurs into the life of the employee. The nominee is a person who is above the age of 18 years. The person who is working in an organization, he has to fill up that nomination form which is been given as per which is laid down under the Gratuity Act. It is to be made after the completion of 1 year of the service. The employee may in his nomination distribute the amount of gratuity which would be paid to all those nominees whose names he has written in the application form, and the percentage of shares which is to be distributed on his death, and it should be more than one. In such cases he has to apply the ratio and the proportions in which the percentage of gratuity has to be distributed. If the employee has a family at the time of nomination, and the nomination shall be made in the favor of one or more than one person or his family, and any nomination made by such employee in favor of any person who is not a member of the family shall be void. So please remember, the gratuity has to be paid only in the favor of the family member, not in the favor of any other person, and nominee of the gratuity has to be filled up in the form J, which has been given under the Act. If at the time of making a nomination, if the employee has no family or the nomination made in the favor of any other person, but if the employer subsequently acquires the family, such nomination shall be void. So suppose a case where the employee is unmarried and he has filled up the form, that is nomination form, he has put his mother's name or sister's name, and after his marriage, if he feels that his nomination for under the gratuity has to be changed, the government has given him the right that he can change those persons from the mother or sister to his wife or his children's. But if you remember, the nomination becomes invalid if it is not been approved by the central government. The nomination can be modified by the employee at the time after giving his employee a written notice. Such form and such a manner has been prescribed by the Act. Every nomination, fresh nomination, alteration, modification, as the case may be, shall be sent to the employer or to the employee and or to the both, who shall keep in the safe custody. Coming to the offences part, normally this particular slide is normally for the employer, for what type of offence what he has made and what type of penalty he has to pay. No court shall take cognizance of the offence punishable under this Act save on a complaint made under the authority of the appropriate government. So the meaning of this particular statement is that the application has to be made by the employee to the employer and is to inform to the authority that my gratuity is due but they are not paying. So this is the meaning of that. No court shall take the cognizance of any offence punishable under this Act save on a complaint. The gratuity, if not paid or recovered within 6 months from the expiry of the prescribed time, the appropriate government shall authorize the controlling authority to make a complaint against the employer, whereupon the controlling authority will ask them to deposit that gratuity within 15 days of the receipt of that particular notice. Cognizance of offence, no court shall interfere to that of metropolitan magistrate or the judicial magistrate court or the first class magistrate court and shall try an offence punishable under this Act. So the courts which are involved are Metropolitan Magistrate Court or Judicial Magistrate Court of the first class will try the offence against that employer. Coming to the offence and penalty, false statement to avoid payment of gratuity, the penalty is 6 months imprisonment or rupees 10,000 or both to the employer. If there is a default in complying with the Act, then the punishment is 3 months to 1 year imprisonment or 20,000 rupees or both. If there is a non-payment of gratuity, the imprisonment is 6 months to 2 years or an imprisonment. Thank you all. I hope you understood in a nutshell the Payment of Gratuity Act, the formula for calculation of gratuity, the procedure for claiming the gratuity, the recovery part, the offence part, and how to appeal part. Thank you from my side.